Just outside Downing Centre local court appeared on quite a serious matter today. It was a mid-range drink drive .130. What made this matter worse, it was a second offence. The first offence occurred only 12 months ago, so within 12 months the fella's been done again for mid-range PCA. He was caught an Uber to a venue where he had no intention of driving. However, throughout the night he met up with some friends. His friend left early with someone else. His friend gave my client the car keys to his vehicle that was located at the venue, and my client was did the wrong thing. He succumbed to having keys in his pocket, and he got into his friend's car to drive home. Now, his friend didn't have an interlock in his car, which he was required to have in any vehicle, which was a mandatory order following on from the first drink drive last year. So he was pulled over for a random breath test. He recorded .130. He didn't have an interlock in his car or in his friend's car, and to make matters worse, his license was also suspended because he hadn't followed previous orders of the interlock program by getting it serviced. His car had broken down previously and he'd missed some service. So once he'd missed the interlock service in the months prior, they automatically suspended his license, his interlock license. So he didn't have a license, he didn't have a car that had an interlock in it, and he was mid-range drink drive. So there was 3 offences that we had to deal with today. The magistrate straight up said, why shouldn't I be sending your client to jail today? And without hearing sort of how the events unfolded, I had to get up and explain the situation. No intention of driving, but did make a very poor decision. He's addressing his alcohol issues. There have been some very emotional issues going on with his family back home in Ireland that he has been dealing with, but he is addressing those alcohol issues. The court today, His Honour was of the view that the matter had crossed the Section 5 threshold, which does mean that he was intent on ordering some term of imprisonment, but he was willing to hand down what they call an intensive corrections order, which is an ICO. And this is where the defendant can serve the term of imprisonment within the community. So he can still go to work, go about his daily duties, live where he lives, but he is for a period of 7 months on this ICO, which basically means that if he does re-offend during that period, then he's at extremely high risk of serving the 7 months in jail. So it is a serious and very intense penalty that he has to abide by, not to breach or break the law within 7 months. So it's basically a warning hanging over his head to pull himself together, not break the law again, and it's a level of specific deterrence for him to obey the law and over the next 7 months, and obviously going forward. So that was the serious main penalty that was handed down. He was also given time off the road. Magistrate reduced the disqualification for the mid-range drink drive down to the minimum period of 6 months. That was backdated to the date when he was charged. He also lost his licence for a further 3 months for the suspended drive. The failed to have an interlock in the car was a fine-only offence, which he got $600 for. So 6 months disqualification for the mid-range plus 3 months for the suspended drive. They usually do run concurrently at the same time, so with the backdating order, he should be able to reapply for a new interlock program in August this year. He really does need to abide by all the orders to a T and do everything correctly and in relation to getting back on the road, getting licensed. And of course, he's got the intensive corrections order hanging over his head for 7 months, which is another thing that will ensure that he cannot put a foot wrong for the 7 months that he's on that period. He will need to report to the probation office to follow any of their directions that they may put in place, such as some community alcohol rehabilitation or programs that they would suggest, and he is obligated to follow any of their directions. So a serious matter, but he was very thankful that he was able to walk out of court today and maintain his freedom. But he's certainly been warned that any further offending will land him in jail, or likely land him in jail in the future. So quite relieved, certainly, especially when the first comments that came out of the magistrate's mouth were why he shouldn't be sending him to full-time custody today. But the court did take a backward step and reduce it down to period of imprisonment, ICO, served in the community. Somewhat relieved client today, but does know that he needs to pull his weight and really behave going forward. No more offending, otherwise he will be seeing the inside of a jail cell. That's our matters here today at the Downing Centre in the Sydney CBD.
I want to thank you for tuning into Borman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900.
Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel because we've always got fresh new content coming through all the time.